First of all, a couple of introductions. My name is Mickey Cerise. I'm with the Department of Human Services. I work in central office in Salem, and I work in the division that's called Children, Adults, and Families, and one of the program areas in that division is child welfare, and that's what we will be talking about today, are the dependency bills that passed this last legislative session. The training is sponsored by the Juvenile Court Improvement Project, and Timothy Travis is in charge of that part of the Oregon Judicial Department. And Timothy is one of the key presenters today and will help us with our presentation. And also with us today is Linda Gus, who's with the Department of Justice, DOJ, and she will be helping also with a presentation on some bills and actually one of the policy option packages that we want, especially the DHS staff, but all the community partners to know and understand. So the agenda that we're going to follow today, as I mentioned, we're going to go through the legislation first, talking about the bills, and we'll go until 11:30, which will be lunch. We'll break, and we'll continue until we complete the conversation about the bills. At the end of the day, at about 1:45, we'll take a break, and local staff here will present the Oregon Safety Model, and that will give them about an hour to present the Oregon Safety Model at the end of the legislative presentation. So all of you should have a handout that is a purple document, and I'm going to take you through this document very quickly. And if you just turn to the first page, it says Legislative Roadshow Talking Points, and that's the section that I put together. This was put together primarily for DHS staff. So it covers all of the bills that's in this document, but it puts the bills in the order of our practice. So it starts with intake and assessment, goes into foster care adoption, and et cetera. And before we go off that page, if you'll look at the bottom where it says Senate Bill 412, and then it says number 1, court, if you will take a pen and cross that out. I put court in there in error, and as we go over that bill, Timothy and or I will explain to you why we're having you cross that out. Then if you go through the document and get to the blank blue page, you will see a single page document that is entitled CFSR Update. Most of you know that we're in the middle of a federal review called the Child and Family Services Review. And this is just a brief update in case you wanted it, and in case it stimulates some questions, we will be able to answer those questions if you have them. We will not go over anything on that page in this presentation. Then if you go to the green page that's blank, and on the other side of it, you will see a document entitled New Legislation Roadshow 2007, and that's where you want to be, and we will generally follow this order in presenting the bills today. So we do sometimes, Timothy and Linda and I do go out of order a bit based on time and other circumstances, but we will be using this section of the document to refer to let you know what page that we're on to talk about a bill. So with that, I am going to turn this over to Timothy Travis and let him begin the Legislative Roadshow.
Thank you, Mickey. Welcome. Good morning. I wanted to say about the taping we're taping today. If you would please, if you're coming from this side of the room, that side of the room, if you remember, would you please duck down a little bit so that your head doesn't present that sort of block on the screen. And you're not required to get down on your hands and knees. You can see how low you'd have to go. It's the cameras on top of that television there. I also wanted to emphasize that I'd like people to be sure to sign in. The sign-in sheets are on the back. If you don't sign in and you're a lawyer, you won't get your CLE credit. But from the point of view of programming, I have to report every year on what I do with the grant money that funds this training. And one of the things I report is how many people were trained each year. So what I do at the end of the year is I take all these sign-in sheets and I add everybody up and multiply by 3, and that's the number I use in my report. So if you'll help me out by signing up, don't sign up at once, but because that would be unethical. But nonetheless, that's why the sign is important. I want to say a couple things about the materials. The materials that are behind the green divider, those are the ones we're going to be using and working off of today. And I want you to look at the last page, please, of that, because you'll see at the bottom, at the end of these materials, there's a note. And what this note says, in effect, is that I created these materials all by myself with my own little hands and my own little computer. Any errors that are in these materials are not the errors of my support staff or anyone else. They're my errors. That includes the intentional misspelling of spelling in the note. And it also, if you go back to the first page of the handout, includes the unintentional misspelling of road at the beginning. I am aware that road is R-O-A-D, not R-A-O-D. It is a proofreading error. In my defense, I'd like to say I've done the program 9 times before anyone pointed out to me that they noticed that road was misspelled. Mickey at one point said that R-A-O-D is a southern pronunciation for road. He's from Texas. He should know. But anyway, that's about the materials. We're not going to cover every bill because some of them are pretty innocuous. They're just basic detail kinds of changes. And also the effective dates of these bills. All of these bills are effective as of the 1st of January unless your materials tell you that they were effective some other time, which mostly means now. Some of these are in effect now, and as we go through, we'll point those out to you and what it means that they're in effect now. The first thing that we do is we talk, before we talk about any specific bills, is we want to give you some context here. Where did these pieces of legislation come from? What in the world did the legislature have in mind when they passed a particular bill or a particular amendment to a statute? And there were 4 main sources of new legislation during this last session. The first source was members of the legislature itself. There are people who are in the legislature, senators and representatives both, who have a particular interest in child welfare. And they got this particular interest in child welfare, for the most part, not because they've ever worked in child welfare, or they were interested in child welfare before they first went through the door into the legislature. They developed this interest because they have telephones and they have constituents. And their constituents, when their constituents have a problem with government, their constituents call them up to try to get help in dealing with the government. And it would not probably surprise you to learn that some of the people who are in the child welfare system, who are the people we work with, the parents in particular, they sometimes call their legislators to talk about how the case is going. And it probably would not surprise you to learn that for the most part, when they call their state representative or their state senator, they are not calling to tell their state representative or state senator what great casework is being done on their behalf. Or are they calling to talk about the wisdom of the judge that's hearing their case? Usually they are, to use the legal term, patootsed, and they are complaining to their representative or senator about what's happening to them. So their senator and representative, not having been involved in the child welfare system previously to their legislative service, they hear this, and they have this kind of mindset about the individual citizen up against the bureaucracy, the unfairness, the unbalance of power, and all this stuff like this. And so they become very interested in child welfare. And 4 members particularly were very interested. They were called, at first they were called the Gang of 4. And they were called the Gang of 4 because one of them liked that. Well, one of them didn't like that. So we all had to stop calling them the Gang of 4, and we started calling them the Group of 4. Okay, so you'll probably hear me say Gang of 4, Group of 4. But these 4 people were involved in a sensitive case review before the session began. And Mickey's going to talk later about a sensitive case review and what it is and such, because sensitive case reviews were institutionalized in statute during this last session, and it's one of the bills that we'll talk about. But just for right now, a sensitive case review, for those of you who don't know, is essentially an audit of a case. And what happens is that people look at the case, what happened in the case, and the idea is, could different decisions have been made? would different casework practices have led to a better outcome, or are there policies that need to be changed as a result of the way that this case developed? And so these four members of the legislature came forward with an agenda of bills, of changes they wanted to see made to the system. And you'll see those changes in the Senate Bill 400 series that's in these materials. Senate Bill 400 and this, 400 and that. And we'll go through those. And these were the ideas that these members of the legislature brought to amend, or to change the system through amending statutes to make the system work better from their perspective. And you will see that they take a family-oriented perspective. Okay? And so that's one of the sources of change this last session. A second source of the changes that we see in this last session was the Department of Human Services. The Department of Human Services, for those of you who don't know, you must have been living in a cave for a while, if you don't know, is adopting a new paradigm of casework, the Oregon safety model, and it was necessary for the agency to get some statutory changes to implement the Oregon safety model. So some of the changes, and we'll identify those as we go through, were made to facilitate this new casework model. The third place that new legislation came from was a group of people that I call the advocates. The advocates. And these were people, there were some lawyers who were involved in child welfare, there were a few judges who were involved in child welfare cases, some CASAs and such. Not everybody in those groups, but some people in those three groups who came to the legislature with an agenda for change. And I think that we can fairly characterize the thrust of this as being they wanted to populate the well-being domain. You know, in child welfare now, the federal government has put these areas on us in terms of evaluating how we're doing in the CFSR and such. We have permanency, we have safety, and we have well-being. And I think it's fair to say that the ASFA pretty well dealt with safety and permanency. But the well-being domain, according to some people, has been somewhat neglected. So what this group did was this group brought in legislation that was concerned about supporting and encouraging families themselves. Not so much deadlines and timelines and consequences and all this, but how are we working with families to support and encourage them? So there was legislation, namely Senate Bill 414, that deals with things like education of kids, watching out for their education when they're in foster care, the casework visits face-to-face between parents and workers and kids and workers, relative placement, getting kids with relatives, sibling placement, placing siblings together. And then there was a little piece about the sort of the plight of the so-called legal orphan, the person whose parents' rights have been terminated, but we are unable to effectuate an adoption for them. So when we look at Senate Bill 414 and a couple of other places, we'll be seeing this concern from the advocates at work. The last source of new legislation is, of course, our good friends inside the Beltway. The federal government is consistently and constantly, Congress is consistently and constantly thinking up new ways that we can do our job better and passing laws that say that if you don't do things this way, you will not get your Title IV-E money. So as a consequence, we had to put some things in statute that the federal government suggested we should be doing. So we will be talking about those things. Those things are sort of collected in House Bill 2190. Which is sort of just this omnibus compendium bill of different kinds of things. But that's where it came from. It all came from the federal government. Out of all of this, really there are some themes that you can keep an eye on as we go through this. And the first important theme is relative placement. The legislature is very concerned about relative placement. Notwithstanding some recent headlines, the legislature as a whole likes the idea of placing children with relatives rather than with strangers or foster parents or community members. So relative placement is something that the legislature wants to promote, and you'll see that as we go through. Several of these bills have provisions that promote relative placement. And that's really important for us to think about, too, as we come upon the CFSR process and the program improvement plans. We know that according to the federal government, we have an inordinate number of children who are in planned permanent living arrangements. And the federal government is very interested in seeing us work to reduce that number and to prevent kids from going into planned permanent living arrangements, but rather to have more of the permanent living arrangements that are higher up on the scale. adoption and guardianship. And one of the ways that we're looking at that we think may reduce some of these planned permanent living arrangements is if we identify relatives early, if we place with relatives early, if we make them the concurrent plan early, then when the karma turns bad for the parents, we won't have a struggle between a current caretaker and a relative. The relative will be the current caretaker, and we'll be in a better position to effectuate an adoption or a guardianship or something like that. So we're going to see through the PIP process those kinds of efforts, and that's right in line with what the legislature says about relative placement. The second theme that sort of runs through this that you'll notice is, as a lawyer, I call this oversight. As a social worker, Mickey calls this casework support. Okay? But essentially, the legislature increased its own oversight over child welfare. You will see a couple of bills that are aimed at giving the legislature a better idea of what's going on in child welfare so that they can deal with the problems of child welfare that they see that are there. So you'll see oversight. Legislative oversight is another theme. And the legislature also gave the court more oversight over child welfare. And I just want to say at this point two things. First of all, the court did not ask for more oversight child welfare. Okay, we didn't go in and say, gee, we need to watch these people more closely. It wasn't our idea. The other thing I want to say is that neither Mickey nor Linda nor I necessarily like what's in these bills. Okay, we didn't think of them, and there's some good stuff in here that we agree with, but when you hear something that you don't like, please don't get the idea that it was my idea, because I'm not going to take credit for it. The third theme that runs through this is the theme of mandatory child abuse reporting. There was some great concern on the part of the legislature about mandatory child abuse reporting, how it's working, how it's not working, ways that we can tweak the system to help the public understand a little bit better about how we do our investigations and the results and such as that. So you will see bills about mandatory child abuse reporting, and that's the third major overarching theme that I see to all of this. So without further ado, and reminding people to please duck under the camera if you can, if you're coming from this side of the room to that side, and remembering that this recording is probably going to end up on the basic website. So if you ask a question, you can bring friends over to your house, and you can turn on your computer, you can stream this presentation, and you can show them you on the internet asking a question. I'm sure you're all going to die to do that. But if you do have a question, please ask it right away. Don't wait for a question and answer period. We always run out of time. There will be no question and answer period. So go ahead and ask questions. Mickey, you want to start?
Sure. Thanks, Timothy. I'm going to start with Senate Bill 282. And first of all, I want to tell you what the bill does. The bill allows the department to reimburse relatives at the same rate that we currently reimburse community foster care. So that's basically what the bill does. All it did was it added blood relatives to the bill. So if you were to pull the bill up and read it, it's a very short change that's in the legislation itself. During the testimony, and when we had conversations about the bill with the legislature, there was an agreement that the funding for this would start July 1st of 2008. So there's a delayed implementation. Any bill that will cost money, we call that a fiscal impact, and we have to go through two different processes. So the bill concept has to be passed, as well as the money has to be added to that bill in order to implement the bill. And the legislature did not have enough funds to fund this bill in its entirety, so they gave us part of the money, and part of the formula that was used to give us part of the money was the delayed implementation. So I want to tell you a little bit of the history of this bill and what's happened here, because I think this underscores one of the themes Timothy mentioned, and that's the theme that we heard during this past session about working pretty assertively with relatives, and by we I mean DHS, when we bring a child into foster care. And what I understand, way before my time, back when Kevin George was real young and he was still with foster care, But what he said was that there was a conscious decision by the Oregon legislature to say we are not going to pay relatives using general fund dollars. So if a relative didn't qualify for Title IV-E, they simply didn't receive a foster care payment out of the general fund pool of money. The rationale behind that went something like this. If that is your relative in foster care and you're a relative who wants to take care of them, you need to step up to the plate and do that and not use state money. You need to use your family resources to do that. And that was probably a good policy decision and a good decision maybe 20 years ago, when that was put into place. But over the last 3 legislative sessions, there has been growing conversations with the legislature recognizing a couple of things. One is that we're having a growing number of relatives step forward and say we will take care of our relatives, but we don't have the resources. Grandparents, for instance, stepping up and saying, I don't have the resources because I'm on a fixed income. And all you can provide is the medical insurance, and I need a little bit of support to help them in their day-to-day living needs. Also, during this period of time, research is beginning to show that when we place a child with a relative, we have a better outcome for that child as an adult. It's starting to look in the long-term sense that that's the best placement for children in the long run, and kind of generally speaking. So all of that came to fruition this session. The legislature not only had a lively discussion about relatives and supporting relative foster placement, but they actually put some money into the system. So the department received $1.7 million in general funds, and that is covering roughly half of the relative placements that we had at that particular point in time. We can, as a state agency, most of you probably know, we can leverage the general fund dollars to some degree with federal fund dollars, and so we were able to increase that to $2.2 million. Now, all of that said, the conversation was to the department, how will you manage that scant amount of money because it will not cover 100% of the relatives? And the conversation during session was around the department using a means test for relatives. And so actually the percentage that was thrown out in a number of testimonies was 150% of poverty level. And so we ended the session with this. We ended the session knowing we didn't have enough money. We also ended the session knowing that probably the 3 big groups that were behind this bill, the legislature, DHS, the advocates for the bill, did not like the means test. No one liked the means test, but no one had a better idea. The legislature charged the department with going back and for the first several months after the biennium began to rethink using the same pot of money and see if there is any other options that we could do to cover 100% of the relatives. And we're still in those conversations right now. In fact, I heard this week that we are planning to do a presentation to the legislature in January, and hopefully we'll have some options for them to consider. Whether or not we can get to 100% of the relatives, we don't know at this point yet. But we're still working on that. So I think one of the important things, as Timothy mentioned, this is one of the things you will see in some of these bills that we talk about the rest of the day. But I think this is a cornerstone for the legislature to begin building on this concept of using relatives. And by we, again, I'm talking primarily about the Department of Human Services. Those of you who went through the Child and Family Service Review, the federal review, know that one of the areas that we showed as not being very strong was concurrent planning and in working with fathers. And so as we develop some improvements in those areas, which we'll be mandated to do, that will fit into this theme that the legislature has put forth this last session around our working assertively with relatives as we go through our foster care system. So, Timothy, I'm going to turn this over to you. Or do you want anything else on 282?
I'll make a comment or two. Okay. The one thing about 282 from the court's point of view is that we have always had this problem when you have a kid who is 4E eligible and is in the care of a relative. and we get to the point where no reasonable efforts finding is being considered, that has jeopardized the funding of that foster care placement, because previously state funds could not be used to replace federal funds with a relative. So this opens up the possibility then that we can cushion that blow if that has to happen. So as Mickey said, though, there's not really enough money to cover all the need, but at least that is a possibility now. I was going to talk briefly about Senate Bill 325, and the reason I'm going to talk briefly about that, it's on page 2, is that Senate Bill 325 is actually sort of a cleanup of a bill that was passed previously. This was a bill that required parents to appear personally at adjudicatory hearings and at termination hearings and at contested hearings to set up permanent guardianships. And those of you probably remember when this actually passed. The reasons for this were a couple. The first is that we often have had the problem in the past when we prepare for a large trial and then we don't have the parent show up. And this is a way, by having them show up for the trial, but also for the pretrial, the important pretrial dates, requiring them to be there in person means that we know that they're still in contact. And so if they're not at one of those pretrial dates, then we can dispose of the case and not have to do all the trial prep. That was one of the reasons. Another reason is because in termination trials and adjudications, for that matter, the primary witness is usually, the first witness anyway, is usually the parent themselves. And so this ameliorates the necessity to not only summons them, but to subpoena them to the hearing. And it also, and this is the piece that really brought it back, it also, this bill, gets rid of an ethical problem for lawyers. And I know that many of you would be surprised to learn that there truly are lawyers who are concerned about ethical problems, which is something I can say because I am a lawyer. But nonetheless, when the lawyer appears and his or her client does not appear, the lawyer has an ethical problem, because the lawyer doesn't really know what it means that the client has not appeared. Does it mean that the client has come into some emergent situation that keeps them from being there, and that they would like to be there, and that they want to pursue the relief that they're trying to get, or to defend themselves against what the state is trying to do? Or does it mean that they really have given up, and they're throwing in the towel, and they don't want to resist whatever the state is doing? So it puts a lawyer in a situation of, geez, if I go forward and resist this thing and I win, I'm not doing what my client wants. And maybe, so the lawyer at this point is allowed now to withdraw from the case, just to withdraw. I'm out of here. And then the state can go ahead and do the prima facie case or whatever the state is going to do. Now, if it does turn out that the parent has run into some unfortunate circumstance, I can remember many times standing in front of Judge Steve Harrell saying, I know my client would be here. I know he wants to be here. I'm sure that he's laying in a ditch somewhere bleeding, and tomorrow we're all going to feel very sorry that we went ahead and took this default. And the judge would say, that's very nice, Mr. Travis. Bang, next case. But if that is the circumstance, if the client is unavoidably kept from being there, there is the possibility of the client, of course, coming in and asking for relief to vacate the order that was made, the order of default. So that is still there. Now, if there is a situation in which we're talking about one of these pretrial hearings that the parent is required to be at, if that parent cannot be there, that parent, through the lawyer, can make a motion to the court to ask to be excused. And the court has the ability to grant that relief to the parent, and will do that if they are convinced that the parent truly is in contact and still is truly engaged. And of course, this doesn't change anything about appearances by phone. If parents are in jail or out of the state or something like that, they can still appear by phone. That is a personal appearance. What we're trying to get away from is this idea of parents appearing through counsel, so that we don't really have the parent there, and that the parent is not there to advise the lawyer about how to proceed. So that is Senate Bill 329.